Welcome back to our channel. Now we are discussing the rights of the sureties, subrogation rights of the sureties or guarantors. Suppose the principal borrower, the company, goes under CIRP, then what about the subrogation right of the sureties? This is what which we are going to discuss with the legal insights and landmark cases. Supreme Court interpreted the rights of the guarantor when a corporate insolvency resolution process is initiated or completed. CIRP initiated or completed against the principal borrower or the surety. So let's begin with the foundational legal principles. Section 140 of the Indian Contract Act 1872. Foundation of subrogation. The law of subrogation finds its core in Section 140 of the Indian Contract Act. What Section 140 says? The rights of the surety on payment or performance, whether a guaranteed debt has become due or default of the principal debtor to perform any part of the guaranteed duty has taken place, the surety upon payment or performance of all that is liable for shall be invested with all the rights with the creditor had against the principal debtor. So this means the moment a surety pays the debt, he stands in the shoes of the creditor and acquires the right to recover from the principal debtor. This is what Section 140 says. But what happens when the principal debtor is undergoing CIRP? There is a company undergoing CIRP or has obtained a relief under resolution plan. Does this extinguish the surety's right? Let's find out through judicial evolution. We'll see the landmark judgment, Supreme Court in State Bank of India versus Ramakrishnan. The principal guarantor argued that Section 14 moratorium also applies to him. Guarantor argued for moratorium, Section 14. He wanted the insolvency proceedings stayed. Supreme Court held Section 14 moratorium is only for corporate debtor. Guarantor liabilities continue. The court did not examine the subrogation aspect, but here made it clear that moratorium has no bearing on guarantor's obligation. So this laid the foundation for treating guarantor and corporate debtor differently under IBC. So another case, if you take in Lalit Kumar Jain versus Union of India, the landmark case validated the input notification bringing personal guarantors of corporate debtors within the IBC ambit. Supreme Court held resolution plan does not ipso facto discharge the personal guarantor. Guarantor's liability arises from an independent contract. Right to subrogation was argued, but the court did not settle the issue, saying the guarantor still remains liable post-resolution. So here the takeaway is subrogation was raised but not conclusively decided. We'll see another judgment, BRS Ventures case. BRS Ventures Investment Limited versus Sway Infrastructure Finance Limited. Now comes the turning point in this case. We'll see the facts. BRS Venture, as a successful resolution applicant for corporate guarantor, part paid the dues. They claim right of subrogation under Section 140 of the Contract Act to recover from the principal borrowing. That is Gujarat Hydrocarbon and Power Cells Limited. Court held partial payment is equal to limited subrogation. Supreme Court held if surety pays only part of the debt, subrogation rights are limited to that amount only. So the court clarified that subrogation requires actual payment. There is no hypothetical subrogation. So This case clarifies that the right of subrogation is not an automatic under IBC just because the principal borrower has undergone CIRP. The surety must make fully payment to step into the creditor's shoe. NCLT, NCLAT ruling in KB Jayaprakash versus Canara Bank. NCLAT held that the personal guarantor, upon part payment, has a right to recover under 140, but such payment not a secured creditor under IBC Section 3, Subsection 30, unless there is a security interest created in their favor. So the decision balances statutory right with IBC. Key legal principle emerging from these cases, whatever I discuss, let's consolidate it. Subrogation is equal to equitable plus statutory right. Right arises only on actual payment, not just on discharge of debt via resolution. So partial payment is equal to proportionate subrogation. Proportionate subrogation. So guarantor's right is not extinguished by approval of a resolution plan. Corporate debtor must indemnify surety under general contract law principles. Guarantor becomes creditor post payment, but not necessarily a secured. Here, one question, Section 131 of IBC help guarantors? Answer is no. Section 31, subsection 1 states that the approved resolution plan is binding on all stakeholders, including guarantors. However, it does not provide relief or moratorium to guarantors. This has been clarified in multiple judgments. That it only prevents guarantors from escaping liability, but doesn't affect their subrogation claim. It only prevents guarantors from escaping liability, but doesn't affect their subrogation claims. So, practical implications. Creditors can proceed simultaneously against the principal borrower and guarantor. Guarantors need to be cautious. Liability survives even if the principal borrower gets resolution. Guarantors must pay in full to ensure subrogation. Banks and financial institutions may resist limited guarantees, citing coextensive principle. Resolution applicants can include subrogation clause in resolution plan with consent. The required or possible legal reforms or clarity needed is IBC may in future include a statutory provision for the rights of subrogated guarantors, or there should be a clear classification of such claims, whether operational, financial, or other. Mechanism needed for subrogated claims to be admitted in CIRP and NCLT proceedings. Supreme Court in BRS benches has clarified that subrogation is not an automatic under IBC and only arises on payment. But the door is open for subrogated guarantors to pursue recovery as ordinary creditors. The PNB, Punjab National Bank versus UP Textile Corporation, the line of reasoning still holds. The guarantees are not nullified just because the principal borrower is discharged in their legal process. Ultimately, no payment is no subrogation. This is the sound principle. So, to summarize, under IBC, a surety can assert right of subrogation only after payment, and that too limited to the amount paid. While the IBC recognizes guarantor's liability, it does not provide immunity or special recovery rights unless full payment is made. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe, hit the bell icon so that you will not miss any of the latest videos. Thank you.